that we have a concurrent custody of the office of the governor, so that we do not leave any doubts that may lead to the fruits of a poisonous tree, if I may make that in reference to the Miranda case of 1967, in that any evidence obtained unlawfully without justification will always be rendered unlawful as having been obtained through the fruits of exaggeration. Thank you, Mr.
Your Honor, in relation to the 2 months and the office of the governor, Your Honor, bearing in mind that the governor's office is executed by the governor and the CECs, could you be kind enough to give further directions, Your Honor, so that in the event the governor is needed to execute his constitutional mandate, then probably there will be a way of doing it other than that office is his office. And unless it has a branch, Your Honor, then it means for 2 months the governor is not able to work. And that goes against the Constitution, Your Honor, and against the people of this county. I thank you.
Finally, Your Honor, in respect to the same, permit me to address the court on the issue of where we find ourselves as a country in terms of budget cycle. We are in the budget cycle that affects both the national government and the county government.
Sorry. We need to understand if Mr. Njeru is seeking a review of your decision so that we prepare to answer. Because we understood what was being done on the other side to be comments post the ruling. But the trajectory is taking appears to be intentional on you varying certain aspects of that. We need it to come out clearly so that we prepare, if that's the intention. Your Honor, we leave it at that. You just restrict yourself to the issue that I've raised, the 2 issues.
Some minutes.
From your side, please, leading. I'll go along. Yes, I think just 3 minutes. This time I'm sure I have estimated properly. We are agreeable to notice being issued for the ESC when they go to access for propriety, so that the accused person may be represented by counsel. We are not agreeable, however, to what Professor Wajakoya is calling concurrent custody. I've never heard about that. The office has been characterized, at least from our end, as a scene of crime. Your orders capture the protection for both sides, that if the investigators are to access, the notice to be given so that counsel for the accused person is present to protect his rights. We are afraid, or rather I'm afraid, but I've shared with my colleagues, we cannot give an undertaking. You know, the role of the prosecutor is simply to institute an undertaking of proceedings. While like I said, I have always had reason to believe Senior Macharia Njeru is a man of his word. But I do not have any basis, or I'm not blessed with the same information he has, that there may be an arrest after this. Secondly, arrests are done by investigative agencies. The ODP does not involve in arrests. So unfortunately, we can't give that undertaking, but we join him in the hope that there's no arrest that happens. However, Your Honor, very importantly, should an arrest ensue on the basis of the same facts where the court has given a bond, then counsel are very aware that they can come back to you and give and seek appropriate orders. I'm not able to go into possible arrest for any other offense, which I'm not aware of. Maybe senior would have done better to add additional facts. But for his suspicion, we are unable to give an undertaking. We join him in the hope that there will be no arrest. But if the arrest is to happen, they know how to seek subsequent orders from the court, or even from the High Court, if necessary. We are obliged. Thank you.
Now that he has made it clear, on the first point, that there's no objection, that we agree. And the second one, which is extremely important, we are in your hands. We do not want to live by hope, even though the issue of hope will not even be where we are. So we are in your hands. Protect the first accused person. Protect the integrity of the order that was granted. I've given an undertaking and said that whenever he is required, we will surrender him. And you can join me in that undertaking, both the first accused person and myself. So, with that understanding, protect him. So that he is not again grabbed outside here, immediately we are outside this court.
Sorry, Your Honor, I don't know whether you, with any legal, give me the position to ask. Or do we understand senior to also be asking for anticipatory bail of some form? I don't understand. If that is true, then we can respond to that question.
Yes.
Just need that clarification from him. If
Yes,
he's thinking,
this is a much I recorded that.
it was an oversight that I didn't respond to that, which my seniors reminded me. Can I just say a word on that? On anticipatory bail?
Proceed.
That this court lacks jurisdiction to grant anticipatory bail. And even if this court had jurisdiction, you have no material before you. What you have is the truthfulness of Mr. Macharia, which is not founded on anything else. So, number one, the court lacks jurisdiction, but even if you had the jurisdiction, you have no material to grant bail. Thank you.
Just to clarify, you cannot grant orders under impunity. As the officers of the court, when they say that the truth blows out and code, that truthfulness, then at the same time you draw that truthfulness by saying that it's not material. At the end of the day, you are a judicial officer with powers, you can exercise your discretion and ensure that again your orders are not abused. That's all we're asking.
consider the issues. Of course, the first request was from Mr. Umbati. It is granted. The second accused, of course, serve the summons latest by tomorrow, 10 a.m. The accused to attend court not later than 22nd of May 2025. Relating to